Okay. All right, it's 9 o'clock. We're going to call this meeting to order. This is a special meeting dealing with the county and Teamsters Local 79. If you would like, we usually start our meetings with the Invocation of Pledge, so we invite anybody that wants to participate in that to stand at this time. Lord, thanks so much again for being able to gather again today to conduct the business of our community. We thank you so much the way you watch out over us and protect us. Lord, we ask the same for those that are out protecting our country even this morning, and that we woke up in a warm home and most with a hot meal, and there's many who don't have that, so we would pray that you would watch over and provide for them. Lord, thank you that you make us aware of these things. We just pray that you would give us great, just humble us in what we do, knowing that everything is a gift from you and only by your grace. So I ask that you watch over us, direct us in all we do today, and in Jesus' name I pray. Amen. Amen. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. Could we have a roll call, please?
This is a special meeting of the Citrus County Board of County Commissioners, the 8th day of February 2022. In attendance are Chairman Ronald E. Kitchen Jr., Second Vice Chair Holly Davis, Commissioners Scott Carnahan and Jeff Kennard, County Administrator Randy Oliver, and County Attorney Denise A. Diamond Lynn.
Thank you very much. This is a special meeting with one purpose only today, and that is we're going to hear presentations from Citrus County, and we're going to hear presentations from Teamsters Local 79. At the end of that time, we're going to be asked to vote on a consideration of rejection of recommendations of the special master, and that'll be the vote that we'll conduct at the end of this. So what we're going to do is I'll start with the county and Mr. Oliver and his team, and if everybody agrees we can do each presentation in 15-20 minutes. Is that okay? Good. That's what we're going to do, 15 or 20 minutes each, and then at the end, because we have read the information, the board's been supplied with the backup documentation and the comments back and forth and counter comments, so we're well aware of the issues. So we'll give everyone a chance to refresh our memory with what we have going, and then we'll move along. Madam Attorney, anything to add, delete?
Does the timer go to 15 or 20 minutes, or can we pick a solid, like one or the other?
Yeah, let's do this. Let's say 15 minutes, and then we'll let everybody wrap it up. Does it go to 15? I'm sure it does.
I like definitive numbers. So.
Yeah, well, that's certainly fair. That way we're getting everybody exactly. Yeah, okay,
Yes.
We're good at 15. So, and we'll start that once the presentations start. But is there any introductory remarks, anything? I want to make sure we're conducting this in a way that's open and fair to everybody and make sure we got all the bases covered.
I think so, sir. You've laid out the ground rules for a fair presentation by either side. It seems like all the commissioners are in agreement with that, so
Okay.
I don't think there's anything further.
Well, what we'll do is we'll give each presenter 15 minutes, and then whatever time the board needs to ask questions, okay? I just want to remind the board that the motion that I'll be looking for at the end of this is consideration of rejection of recommendations of the special master. So that's what the vote will be, and that's what the motion will be. So just let's be clear about that. We're not here to renegotiate contracts today. We're here to hear both sides' presentation and then make a vote on that recommendation. Okay? Everybody clear? We're good? Okay. Mr. Aller? And you can start the timer once he starts talking.
Good morning, Randy Oliver, County Administrator. If we can go to the next slide, Doug. There were 3 bargaining sessions that were held, one on June 17th, August the 3rd, and August the 5th. As noted there, the union declared impasse after the meeting on August the 5th. We believe that was a bit premature, but that's their decision, and once that decision is made by them, it takes on a state process. There's a state specified process as to how things follow after that date. On November 15th, there was a meeting held with the special master And then on December the 10th, which you all have received that, the special master issued a written report with recommendation geared towards resolution of the issues in the dispute. The subsequent slides will detail the recommendations not agreed to by the administration. Next slide. The first one is annual leave. Our current policy, which is what we're recommending continue, is if you have less than 5 years, you get 2 weeks of vacation. Over 5 years, you get 3, and over 10 years, you get 4. Special master recommended over 15 years, you get 4.5, and over 20 years, you get 5 weeks. It's our opinion that that's excessive based on the market, and that's one area that we are very competitive with the private sector. We're very liberal as it relates to the leave that we give to our employees, and that's one of the benefits that they have as a county employee versus working for somebody in the private sector. Consequently, we recommend that stay at the status quo of 3 weeks over 5 and 4 weeks after 10. Next slide. Sick leave, the special master recommended that a person could use 1 day a week or 1 day a pay period, if you will, for annual leave. Right now, we require them if they're sick, and we're very receptive to that. We also comply with the law as it relates to benefits and time off. But we require them to use all their sick and vacation time before they go on leave without pay under FMLA. Under FMLA, they get certain protections, and obviously they get those. That's a federal requirement. What the arbitrator wanted to do was let people piece that leave out. And the issue that we have with that is that if a person takes 1 day this pay period, and then 1 day next pay period, 1 day the next pay period, you could essentially have 52 days and weeks, and we would be paying the insurance the whole time without, if this wasn't a requirement. So we recommend that requirement continue. So we're recommending, again, status quo on that. The next one is emergency pay. I don't think that the special master totally understood this. What this would do is if a declaration of emergency was issued, which we typically have done with a hurricane, okay, most recently we did with a pandemic, if this provision would have been in effect, it would have bankrupted the county. It would require, when there's a declaration of emergency, right now, when the office is closed or the offices are closed for a day or 2 or 3 days during a hurricane, we pay the field staff for being off 1 day, and then we pay them time and a half for coming in. So they're getting 2.5 times the salary. Under this provision, however, it would require any time there is a declaration of emergency, while that declaration is in effect, that we would have to pay them time and a half. So during the pandemic, we would have to pay them time and a half for the total amount of time that they worked, which would have increased our wages by 50% during the pandemic. Okay, obviously that's an unbudgeted item. I would note that during a hurricane, while people only see the time when the hurricane is coming or a tropical storm's coming, and then it passes, it's very common to keep that declaration of emergency open so we can do cleanup and things like that. So we believe that this provision is egregious and, as I say, would bankrupt the county. The final one, which is actually a little more complicated, is the bargaining unit requested 17% or $1.50 an hour increase. Next slide. What we came back with was 3%, 40 at the bottom of the range, 20 at the top of the range. Okay, and the reason that we did this is we're working towards getting to the $15 an hour minimum wage that we have to be at as of 2026, and that brings the bottom up. One of the problems with our compensation is the ranges are too broad. The top end is good, the bottom end is low. I'm going to be candid, we're going to be proposing a class comp study for trades workers in the next budget. But if you have a pay range from $20 and it's 60%, the top is 32. Well, the 32 is very good. The 20 is admittedly a little low. But we need to bring those two together more closely because in the private sector right now, if you want a truck driver, they pay a certain amount of money. It may vary $1 or $2, but that's about it. It doesn't matter how long you've been there. It's like I always say, you can have a person with 20 years of experience, which is legitimate, or I can have a person with 1 year of experience 20 times. So we are recommending that the board give the same 3% across the board to everyone in the bargaining unit, 40 at the bottom, 20 at the top, and 30 in the middle. So it's scaled based on where you're in the ranges. The purpose of this is to push those ranges more closely together to bring this where it needs to be. Next slide. Again, this just reiterates the 3% across the board, 40 at the bottom of the class, 20 at the top. And this would be the same increase as all other non-bargaining unit employees. If we do something here, different here, I would recommend that it apply all employees equally. I believe in treating all employees the same way and treating them fairly. Next slide. So in recapping, we're recommending that the annual leave remain at the status quo, which is 3 weeks after 5 years, 4 weeks after 10, that sick remain the status quo, and that they have to use any annual leave or sick leave before they can go on leave of absence without pay. Next slide. Hours worked, the emergency pay provision not be included in this agreement and remain in the employee handbook as it is. And then on the wages, 3%, 40 at the bottom, 20 at the top, and it would be effective 2 pay periods after the board makes their decision today. That gives us time because I don't want to have to go back and do a lot of retro calculations. I always prefer for the contract to be tied up before the new contract period starts. And as you're aware, we've done that in prior years, but unfortunately that didn't happen here. So with that, that concludes my presentation. Thank you.
Okay, thank you. Does the board have any questions, Mr. Oliver? Just to clarify that last statement, this is last year's contract, right? So what's being proposed here, if agreed to, would be retroactive, correct?
It's not retroactive the way that it's proposed, and that was not recommended by the mediator either.
Right, okay, all right, very good. Okay, no other questions. Okay, so we're ready for the Teamsters Local 79 presentation.
Good morning.
Good morning.
My name is Sharon Ayala. I'm the business agent. John Schulte is also a business agent. He's going to be assisting me with this. I would like to read and introduce the letter that we sent to the commissioners. And it states, in accordance with subsection 447.4034B, Teamsters Local 79 submits its recommendation for settling the dispute and past issues in the above referenced matter. Teamsters Local 79 recommends that both parties abide by the special magistrate's recommendation dated December 10th, 2021, with all wage increases to be paid retroactive to October 1st, 2021. John?
My name is John Schultes. I'm Secretary Treasurer of Teamsters Local 79 as well as a business agent, and I was involved in the contract negotiations that led to this dispute. So my recollection is that out of all the proposals that we had that went to impasse, it was basically narrowed down to 4 that the county administrator was at dispute with Teamsters Local 79, or at dispute with the recommendations provided by the special magistrate. I hear the term special master. My understanding it's interchangeable, special master, special magistrate. We prefer to use special magistrate because that's the language that's used in the statute. So out of those 4 disputed items, the union is willing to accept, as Ms. Ayala just explained and read from her letter, the union's willing to accept the special magistrate's recommendations in their entirety. Since this dispute is centered on a contract that begins its term in October 1, 2021, it is the union's understanding that any increases shall be paid retroactively. I guess that might be a question for the special magistrate to clarify after a decision made by the BOCC. However, Mr. Oliver is correct in the fact that the special magistrate's recommendations does not make a reference to whether or not retroactivity is included. The union's understanding, it's natural that it is and that it would be because, again, the dispute is for a contract beginning October 1, 2021. With respect to the decision that is before you today, the county commissioners have to decide whether or not there's a recommendation that's put out is more important, more accurate than a recommendation of the county administrator, Mr. Oliver. And the way Teamsters Local 79 sees it, there's a fork in the road today. One fork in the road is that we accept the recommendations of an expert. Ms. Sargent, Amy Sargent, was selected to preside over this dispute. She was selected through the process of striking arbitrators or special magistrates from a list provided by the FMCS, Federal Mediation and Conciliation Service. It's a government agency that screens, qualifies, and maintains a roster of arbitrators, legal or labor relations experts. We got such a panel, such a list from the FMCS, and each party went through the process of striking the names off that list that we felt weren't the best pick for the job. Every arbitrator has a track record. So arbitrators that continually to vote in favor of a union or recommend or award in the union's favor tend to get a record as a pro-union arbitrator. That would typically be the first strike off the list by an employer. Similarly, if an arbitrator has a track record of being pro-employer, all of their awards seem to just go to the employer all the time, that would be the first pick from the union. And so that process is a fair process because we end up with the last person remaining on the list, which in this particular case was Amy Sargent. Amy Sargent was determined to be the fairest, most equitable arbitrator slash special magistrate for our dispute. We picked that expert. We paid for that expert. The county and the union split the costs for the expense of having that expert deliberate over our dispute. I don't mean any disrespect to Mr. Oliver at all. I don't think Mr. Oliver is a labor relations expert. I don't know him that well. I don't think he's an arbitrator. I don't think that FMCS has him on their roster as being an expert, an arbitrator, or a special magistrate. So how is it that the county BOCC would vote in favor of a non-expert over the expert's recommendations is kind of concerning to us. One might argue, well, Mr. Oliver has his finger on the pulse of the workers. I don't think that's the case. Why would he be wanting to take things away that the special magistrate recommended for the workers to enjoy to get something better for themselves if he had his finger on the pulse of the workers? I've never seen Mr. Oliver attend a single contract negotiations ever in all the years I've been here, and it's been about 15 years that I've been representing BOCC employees. I don't think Mr. Oliver's been here for that long because I've seen a few county administrators come and go, some of which who attended contract negotiations. Mr. Oliver never has. He didn't even attend the special magistrate's hearing. Apparently he didn't think it was important. If he thought it was important, he would have been there. If he had been there, he may have heard from his own employees or the county's own employees as to what the issues are that are important to them. So I don't think Mr. Oliver has his finger on the pulse of the workers any more than the special magistrate. And in fact, if anything, the special magistrate at least heard the testimony of the workers who were called as witnesses. The special magistrate asked questions of the workers, heard with her own ears, her own eyes. She deliberated over the facts that were presented to her from both the union and the county. She deliberated over the documents, over the witness testimony, and the post-hearing briefs that were submitted. And she issued her recommendation. Did the union get everything that the union wanted in negotiations? Absolutely not. Not even close. Did the county get everything they wanted in negotiations? No, absolutely not even close. But we found a fair expert, an outsider, to deliberate over this dispute and to issue her recommendation, and the union is willing to abide by that. And that's what we suggest, that's what we're here today, is that the county abide by the special magistrate's recommendations as opposed to a non-expert. Take the recommendations of an expert over a non-expert, and that's pretty much our presentation.
Okay, thank you. Board, any questions? Thank you. Okay, I just have a couple of comments in response, and then I'm going to make a motion, and then we'll see what happens. First of all, I'm a little thrown back that Mr. Oliver presented facts and data, and you attacked Mr. Oliver basically half of your presentation. So to me, that didn't respond data to data. So, Mr. Oliver is the expert that we employ because he's our expert. So when you say he's not an expert in labor relations, I ran a business for many, many, many years. And you might say, well, because I'm not a judge, I might not be an expert, but I think when it comes into dealing with employees, I have a pretty vast background in that. So with all that said, that's why, the motion that I'm going to make is to reject the recommendations of the special master. That'd be my motion.
Second that.
So I have a motion and a second. Board, is there any other discussion? Yes,
Reject
ma'am.
all of them, or reject the four that Mr. Oliver
The four
is-
that's
Okay.
in front of us, right?
Just-
Reject
Just wanted to make sure you were clear on that.
the settlement impasse issues in dispute,
Those
item
four.
B1.
Okay.
Okay? Okay, any other board discussion?
I'm trying to figure out how to frame this. I always like to look at both sides of an issue, and I like it when people look at both sides of an issue. And I came in here to be empathetic to the Teamsters' needs, but I have to say that you lost me by not addressing the very critical aspect of time and a half during emergency, state of emergency. Literally, we were in a state of emergency for months, which means it would have bankrupted us. And, for you to not want to budge on any of those issues makes me feel like we're not all willing to meet in the middle. So I'm sorry for that, but I was disappointed with the presentation.
Mr. Chairman, am I allowed to respond?
Shoot, no, not yet. We laid out the rules, right? So according to my agenda, the only other input would be from the public. So do we take public input on this motion, or is this motion clearly between the parties?
The public does not get input. Well, you know what, Commissioner, it's at the discretion of the board.
So it doesn't hurt? Okay.
It doesn't hurt,
Now, in
no,
this
sir.
case, would the representatives be considered public, or are they parties?
No, sir, they're parties.
So in my opinion, since everybody had the time to speak, it would seem that if we give rebuttal to one side, then we got to give rebuttal to the other side, and we're back and forth.
Well, I think that it would be rebuttal to the other side's presentation, not to the decision maker's
Right,
thought process.
right. Because my understanding is we were supposed to make our decisions based on the evidence presented.
Yes, sir.
Okay, good. So in that case, I'll have to decline your request to speak.
Mr.
So-
Chair?
Yes, sir.
I'll just make one quick comment.
Yep.
I agree with the points that were made by the board. I do think that the gentleman provided some good points, some interesting points regarding the selection process of the magistrate. However, fire services is one department of a much larger, one component of a much larger engine in county government. And Randy Oliver does a masterful job of keeping that engine running. I'm gonna support your motion and vote against the recommendations of the special master.
Okay, so is there any other board discussion? Okay, seeing none. Madam Clerk, would you give us a roll call vote, please?
I'm sorry, before the clerk
sorry,
starts,
yes.
I'm sorry, Commissioner Kennard, you said fire services. I think you misspoke. I think you meant to say Teamsters.
Teamsters.
I'm sorry. I just
Right.
reflecting on that.
Yeah,
Chair, first, I wanted to clarify the motion because I heard your motion, but I did not hear the second.
The motion, I'll just rephrase one more time, is to reject the recommendations of Special Master Amy Sargent and settlement of impasse issues in dispute between Citrus County, Florida and Teamsters Local 79 and Commissioner Carnahan.
Carnahan.
seconded
Okay,
that.
thank you.
Okay.
Okay, sir. That will be Commissioner Kitchen,
Aye.
Commissioner Carnahan. Commissioner Davis,
Aye.
and Commissioner Kennard.
Aye.
Thank you.
Okay, so the motion passes 4-0, and we have completed that item. So our next item comes up at 11 o'clock, or 10 o'clock, unless we have anything else more to conclude on this.
No, this hearing would be concluded.
Okay, so at this time, we will close the special meeting and reconvene at 10 o'clock for our next workshop.